Now, I'm thrilled to kick off day 2 of the 6th annual review with our session 4 on cost, pricing, and audits. Our panel members today include Brett Calhoun, Paul Pompeo, Greg Bingham, David Bodenheimer, and I'm pleased to introduce the session moderator, Mary Karen Wills, who is the Managing Director of the Government Contracting Practice for BRG. Mary Karen, over to you.
First, an update on DCAA activity and audit guidance. Next, other audit activity that occurred during the year. For example, OIG, DOD, OIG, GAO, and third-party audit status, cost allowability developments, cost accounting standards developments, truthful cost and pricing activity. And last but not least, we'll touch on kind of the CARES Act and some of the cost implications associated with the COVID-19 pandemic. And certainly we're saving time for a Q&A at the end. And this will be a fairly interactive panel so that we certainly welcome your questions as well, and we'll try to address them to the extent that we have time. So with that, I'm going to turn it over to Brent, who will lead us off on DCAA and other audit activity and audit guidance. Thanks, Brent.
Hey, thanks, MK. All right, one more slide, Alan. All right, well, we'll just start off with a bit of an overview of what DCAA has been up to. The last reported year that we have is fiscal 19. I look forward to seeing what their annual report to Congress discloses for fiscal 20. I like to look at a lot of this data over periods of time. Many of you that are dialed in today have probably seen me in years past provide what I call it my forensic analysis of DCAA's audit reports to Congress. Much of the data is different now than what it was in the earlier years, starting in 2011. But I at least provided a few 3-year trends here. We can see that the activity has been relatively consistent throughout all of for the last 3 years. Extending the list backwards, for audit reports, all the way back to 2011. We see that the quantity of audits that DCAA performs, or at least what they're calling audits, has continuously slid from as many as 7,000 or 8,000 back in 2011 to just shy of 3,000 in fiscal 19, and we'll see where that comes out in fiscal 20. So the overall audit activity has really decreased. But the response there we hear a lot is that the quality of those audits have increased. I'll let you all in the audience be your own judges of that. We can also see that the costs of doing all of the auditing has remained relatively consistent over that 3-year period. The audited dollars jumps around a little bit. And then finally, we have, it's a popular statistic, not quite sure how it's derived, and would love to actually have somebody audit these reports to Congress so we could understand how these things are derived. But the crowd pleaser favorite is the sustention rates. And those have remained somewhat steady over that 3-year period as well. There are some strange anomalies in the data that make me say, Like for instance, if you look at audit reports, especially fiscal year 18, there's just a very odd blip in special audits and a very odd blip downwards in incurred costs audits. But if you look at audited dollars, for instance, that trend seems to be sticking pretty consistent there. So I'm not sure if somebody transposed some numbers somewhere in the reporting, but take the data with a grain of salt. But the overall end message of this is DCAA is out there chugging along, but they have slid to a particular lower level of audit activity and seem to be maintaining that. I'm sure my esteemed panelists might have some comments, so I'll pause right there in case somebody wants to jump in. Okay.
Anyone? Yes, David. You're on mute.
On the sustention rates, I agree with you, Brent. That's one area that DCAA should be audited to determine what the basis is. I have not seen sustention rates on any of the audits that I've looked at, and I know when we talked about this separately, That was the consensus of the panel. So I assume that there's no backup information for the sustention rates that's publicly available. Is that right?
Yeah, David, I've tried to do a fair amount of digging, and there's a fair amount of information in DODIG's semi-annual reports to Congress that have some information out of DCMA's audit tracking and management system, but those have never really shed any light on these particular numbers. And from my personal experience, I think just like yours, that these are not the sustention rates that I've experienced. And to the extent that we have experienced them, it's not because they necessarily found something. It's because our clients have decided to just settle it versus pursue it.
There is one recent DODIG report in 2021 that speaks to, how effective DOD's contracting officers are with respect to actions that have been identified as question costs, both direct and indirect. And, I didn't try to cross-reference any of the findings there, but it's highly critical of DCMA in not rendering opinions on direct costs that have been questioned by DCAA and trying to point accountability there and ensuring that they're looking at question direct costs as well as indirect costs. But it's a little critical of not resolving or not sustaining, findings by DCAA. So it does bring into suspect kind of the sustention rates that I think we're seeing here. I'd also question the forward pricing sustention rates. I don't know about you all, but I'm not seeing that many final opinions on forward pricing rates that, maybe it's gone up a tad, but just approved forward pricing rates, it's really tough to get those. So it seems like a high sustention rate there too. And Greg, I saw you had a hand up.
Yeah. And I'll just comment that in my experience, the sustention rates sometimes are exaggerated, where the DCAA will say that a certain category of costs are unsupported. And maybe other auditors would go through and say, well, 85% of that is supported, and 15% we have some questions about. Well, they'll just question the entire category, and often. And so then that shows that they're flagging it for the contracting officer. Hey, this category doesn't have adequate support, but that tends to exaggerate or inflate the sustention, the amount questioned. I'm sorry, the amount questioned.
Right.
Mm-hmm.
Well, before we move on from this slide, I do, because David's going to have some additional news flashes with respect to truth and negotiations audits and resolution of those, and those are classified under the other audits on this slide. And if you look on the audited dollars, it's a very low amount of money. I'm not sure if David will have some thoughts on that coming forward, but the sustention rate also seems to have taken a turn south. Perhaps that's because there's less other cost audits and more business systems audits occurring in fiscal 19. And it's also unclear from DCAA's audit, annual report to Congress how much of these things, and maybe they'll report it separately in fiscal 20, which is the full fiscal year of using the IPAs to do the auditing, whether it will be reported separately or combined with these numbers. I suspect the latter.
Yeah, and as you draw attention, thanks Brent, drawing attention to the special audits and the other audits, and so your slides show that these, the special audits includes REA claims and terminations, and then the other audits are CAS, TINA, and business systems. I would just say that make sure that the audience is aware that, like some things, incurred cost submission, forward pricing agreements, those are fairly rote or routine. I mean, there's a lot of steps that are the same in every audit, but then when you get to REAs and claims, they're quite different. And even though there's audit guidance written for REAs and claims, it's just, every REA claim is different, and it requires a lot more creativity and judgment on the auditor's part to audit an REA or claim than some of these other areas.
Well, since we don't have any data for 2020, we can report out on some of the activity that we've seen from DCA, at least public disclosed activity. And it's been a very quiet year for DCA overall. only have a handful of memorandums for regional directors where they're pushing out policy across the DCA organization, also available for public consumption. We pulled out 4 here for your enjoyment. We'll start at the oldest first. And none of these things particularly have any sizzle to them, but these are the ones that were worth mentioning. Not long after everything kind of ground to a halt as a consequence of the pandemic, they issued some audit guidance saying, hey, look, auditors keep auditing. No, you can't necessarily get into the contractor facilities to actually physically inspect and observe particular documents, but that's okay. Work from PDF copies, share screens, and view things that way. And to the extent that we need to go back later and just make one last verification step, we will do that. As far as I'm aware, that there hasn't been any particular controversy with that, nor does it necessarily change the appropriateness of the audit reports that they put out. And it's been my impression that DCAA, unless there's something controversial, probably will not go back spend a lot of time double checking the things that they didn't get to see in person.
Well, and Brent, while you're on this topic, do you want to talk about floor checks and in floor checks in a virtual world? That just seems so strange to me.
Yeah,
it would be good to hear comments on that at some point.
Well, I'm going to turn that open to the peanut gallery. I've got many of my clients are in fact going through virtual floor checks all year long. There hasn't been any. It's odd, and the questions they ask are odd, but I don't think there's been any big issues associated with it.
Yeah. And just to make sure that the audience is aware, in the old school way was an auditor would walk around with a clipboard, walking around the factory floor, or walking around the office, and looking at people to see, were they showing up, were they at their desk, what were they working on, that sort of thing. Ask them a few questions, and so it's quite different now in the virtual world.
Yeah, and I think all of the typical hygiene comments that we would normally make in managing an audit, I think still apply in the virtual world. So as long as a good audit management and hygiene is happening, things should be okay. Although everything's just a little goofier now in the virtual world. So in August, this one really surprised me, not because it's a surprising thing, but rather than sit around and wait for OFPP to get around to calculating the contractor compensation limits, DCA just went ahead and ran the calculator themselves and pushed it out to the contracting community, which I thought was actually kind of helpful. There's been some low-level rumbles of whether you can or can't calculate the cap on your own. I'm like, well, it's a statutory formula. Of course you can. Anybody with a calculator can calculate it. So DCA took it up on themselves, did that, and pushed it out, which I thought was actually, in the grand scheme of things, more helpful than not.
And the audience should note that Brent said the DCA was helpful. Anyway, take it away.
I put an asterisk next to that. Not always.
This is recorded.
It is recorded.
Yes. It will be used against you.
I'm sure I have no shortage of those things. Okay. September, some new audit guidance came out, and I just had my first recent experience with this exercise. Something called a contractor information survey. This is largely aimed at the smaller contractors, perhaps ones that wind up with a lot of low risk, incurred cost audit rate finalization memos. And it's an interesting little, it's not particularly burdensome. One, I get really irritated when I see the auditors or DCMA pushing out yet more things for our clients to go fill out that aren't required in their contracts. But after looking through this, and as many times as I know it's just bang head here trying to push back on this stuff, it's really not that hard of a form to fill out. It resembles a lot of the aspects of a contractor, a prospective contractor accounting system survey. So the SF 1408, a lot of questions there. They're not asking for long, detailed, drawn out answers like their typical accounting system audit internal control narrative form that they've been sending to contractors. But it does have several interesting questions in there, and I can definitely tell that the document is designed to flag certain areas of risk. Two that jump out that are noteworthy is if it's a privately held company, if it's a family business, In other words, multiple members of a single family would be participating or owning the business. Because they make a very important distinction about that in the ownership structure. And the other one is related party transactions or working together with other related parties if it's a privately owned business. So those are some pretty big risk factors in the auditing world, and I think that's what they're trying to get their arms around. If we have to start auditing some of these smaller contractors and they're not necessarily flagging in the overall risk assessment process, can we gather a little bit more information to help us fine tune that? So for all of you out there that are a smaller business, this is, if you haven't received this yet, expect it in your email inbox. You'll be filling it out. It's not a heavy lift, but just be aware of what they're trying to do or what we suspect they're trying to do. And then finally, December of this year, last year, not long ago, some audit guidance on the cost accounting and audit implications of the COVID-19 relief provisions, mainly from the CARES Act, but then there's been some others as well. And the large focus there is just no double counting. There's aspects of it for Section 3610. There's aspects of this associated with the PPP loans. There does seem to be a big concerted focus on cost reimbursement contracts. Not a lot of discussion or any discussion on T&M or fixed price contracts. So, after reading it, I kind of did the shoulder shrug. It's like, okay, sometimes I take issue with some audit guidance, and other times I'm like, for the most part, this makes sense. And I think it falls into that category, but I'll let the bond to those things. So we all got a big meh out of the audit guidance.
Yeah, true.
All right. Hey, we're trying to find something exciting to tell you, but the lawyers have got some good case stuff to discuss soon. So.
You always have to leave it to the lawyers.
That's right. Yes. Us accounting types. So we got the short end of the stick.
Yeah, us accounting types got the memo on no ties, Paul. But anyway.
And apparently no style. But that's another story altogether. So, ready to move on?
Yes, sir.
Business systems, next slide.
Yeah. So let's see, who's this? I'll just were you still going to talk about this presentation?
I'll do a quick. Yeah, I'll do a quick public service announcement just because I helped write this. This is all part of it's been tweaked a little bit since the 8 or 9 panel. But it looks like we finally got in this year's NDAA, which became law through through a veto override. The term significant deficiency has been replaced, at least in United States Code, to now read material weakness with some additional context and language to describe that. And we thought that this was an important thing to happen because the way the government deals with significant deficiency as that term is used in the law and regulations previously really didn't line up to the accounting and auditing the private sector, where it's really 3 tiers: a material weakness, a significant deficiency, and then just a regular old deficiency. So that has been remedied. At least there's going to be some language consistency between the auditing in government contracting versus more private sector auditing. And there's a whole bunch of definitions that go along with this stuff that will ultimately, hopefully, sometime sooner versus later, make their way into the DFARS, because this was the first step that needed to happen for a lot of regulatory updates, as well as transforming the accounting system criteria, there's 18 of them now, and it's a hodgepodge of things written in different perspectives for different reasons, to basically boil those things down into 7 criteria, which are much, much more consistent. And it's an instruction on what a contractor's accounting system must do, and how the contractor accomplishes those things would be up to the contractor. So it's a much simpler rubric for accounting system compliance is what's in the works. And this was the first step that needed to happen for those things to occur. Just an additional thing, we understand that DoD, not necessarily DCAA, because DCAA and DCMA were involved in drafting and creating this new rubric that's going into place, but DPC was not a fan of it. So we're pleased that it's made it through to this far, but to the extent that DPC maybe still has objections with it, we don't know what it's ultimately going to look like, if anything, once it goes through the regulatory update process.
So do you think, though, that this will really change much how DCAA is going to identify deficiencies or material weaknesses now? And it seems to me that in the business systems, regardless of what the definition is, DCAA comes in and finds things anyway that don't seem to meet the definition. Do you feel a degree of confidence that this is going to have more, I don't know if accountability is the right word, but more direction for auditors?
It's a great question, Paul. I don't want to use the word confidence. I have hope because it does provide now more definitional structure around what a significant deficiency versus a material weakness is. And I think it sets the bar a little bit higher for a material weakness. Like, we have to actually be able to demonstrate something rather than just call it something. And that in of itself might not be the thing that makes the difference, but if the accounting system criteria changed to what the 809 panel recommended, which we hope that will happen, it moves away from a pass-fail type view of the 18 criteria to does my system have the appropriate controls designed and operating effectively to accomplish these 7 things? So it changes the nature of the conversation. And will that make a big difference? I don't know. I mean, in my view, and based on the updates that DCAA has been doing throughout 2020 to many of its accounting system audit work programs, it's already what I think has started to embed some of this 3-tier deficiency language into its audit work programs already. And it's really hokey right now because it's called a significant deficiency, and then it's a less than severe significant deficiency, which is a big head scratcher. And I got conspiratorial at first about that, but then I zoomed out, and it seems like they're really trying to modify the nature of how they're looking and doing their audits to embrace this new material weakness versus significant deficiency versus garden variety deficiency. Now, again, there's still a lot of hope in that. I have no direct knowledge, but if maybe I can wish it true.
Why don't we move on to 11? I'm keeping an eye on the clock here. We're about ready to close out our first topic with 2 more things. Interestingly, there's a case that oddly is out of the Civilian Board of Contract Appeals, which is not typically the arena we get a lot of case law in the space of accounting cost of pricing. And the other thing is that it deals with not so much a question of allowability or CAS or TINA or anything like that, but the subject of audits kind of generally. So SRA had a contract with the Department of State, and state uses DCAA for their auditing as opposed to their own IG's office. And so this was, typical ICS audits group for 12 through 15. And DCAA, as we find often, says that the contractor failed to timely provide supporting documentation to substantiate claim costs. Here it was for subcontractors and ODCs to demonstrate that they were reasonable, allocable, and allowable. And as Greg pointed out earlier, often what happens is that the auditors will come in and say, okay, well, we're going to just disallow everything and assert question costs. And in this case, it came to $29 million. So we're not talking about a paltry sum. During negotiations, so this is a little bit after the fact, and when they're dealing with the ACO, SRA attempted to provide supporting documentation that it hadn't provided to DCAA. Now, again, this is very commonplace in the way that audits unfold. You have the RFIs that you get from DCAA, they're looking into certain subject areas. The contractor's never going to know for sure, where the focus is. They respond to those questions. They feel, the contractors believe that they're giving, the sufficient documentation. And then it's not until you get an audit report or a draft, depending on what you're allowed to respond to, that maybe there's more definitiveness and an opportunity to go back again, and then with your ACO and provide things. So if we can go on to the next slide on 12, this is a two-parter on this case. Well, Department of State issued a contracting officer's final decision. So they asserted basically a government claim for the full $29 million in disallowed costs, and relied on this same position that SRA failed to produce documentation during the audit. But here's where it's really troubling. It says that it was in violation of the FAR retention requirements. And you'll note, I didn't point it out, but on the top of the prior slide, their contract included the standard audit clause and the allowable cost and payment clause. And there's language in those clauses that talk about, the reasonable access and reasonably providing information. So, so there were two issues that came up in this case, and one of them is really just kind of a procedural thing that's a little less imperative to our discussion on audits. But the contracting officer, they issued their final decision. The government filed a complaint before the CBCA, and they attached the DCA audit. And so SRA filed what's referred to as a motion to dismiss. So what does that mean? That means that upfront, SRA is just trying to get rid of the case, not addressing the merits of the issue, but saying there are some defects in what's going on here, and so the government's case should be dismissed. Now, one of them was on a failure to provide adequate notice as to the basis of the amounts of states' claims, because what they were alleging is all you did was slap the audit report on, and that, that doesn't constitute a sufficient complaint to identify the cost. But the other one, which I think is more important to our discussion, is this concept that they failed to state a claim upon which the board could grant relief, because it's premised on the idea that there was some obligation under the FAR clauses to provide additional data or documentation within a reasonable time or in a timely manner that would somehow affect the allowability of the costs. And so as to say that that standing alone maybe somehow was a breach of the contract, that the contractor didn't provide the information in accordance with either the audit clause or the allowable cost and payment clause. And what's troubling about this, now again, it's just procedural, it doesn't get to the merits, but the civilian board denied the contractor's motions for dismissal on both bases. They said, well, everything was in the audit report and you had enough information in the audit report to explain the Department of State's claims. So the fact that the contractor just slapped the audit report on wasn't a procedural deficit. And also that the Department of State had asserted a plausible claim that SRA failed to support its incurred costs by failing to provide data in a reasonable way. Now the case talks about, well, there's open questions as to what reasonable time might mean and so on and so forth. So this will be interesting because I don't think there's cases out here that deal with this kind of issue. And I think it's particularly troubling because we see DCAA all the time disallowing costs because of insufficiency of data. So I would just say, let's keep your eye peeled on how this case unfolds. Presumably it's still moving on. It's probably in discovery and other elements of litigation, unless it gets settled. But this is a case to keep eyes on. So that's what I've got to share on that. But David.
David, you have a comment on that?
Excuse me.
Let me make two quick comments. One, it was good, Paul, that you pointed out this is Department of State, the civilian agencies. I know you've had similar experience with DOD that often the ACOs are willing to accept additional supporting data to make it go away. So this is interesting that a Department of State ACO would want to take on the burden of litigation and testimony when it could have been resolved otherwise. The second thing, the motion to dismiss, it's a difficult thing to win, no matter what forum you're in. I mean, just when I looked at defective pricing alone, 90% of the summary judgment motions failed, and one of those was on a procedural issue. So motions to dismiss are generally hard to win. You hope they don't lock the judge into a particular frame of mind or position that will carry through the rest of the litigation.
So
I had a couple.
I'm sorry for a second. I was just looking at, I've been keeping an eye on our Q&As, and somebody asked a question that says, do we have a standard as to what DCAA considered to be proper support of the subcontractors' incurred costs? Well, the answer to that is no, because they're saying that that what was provided was insufficient. But they didn't delineate. They didn't say, "Oh, this is precisely what we would need." So I'm sorry. I just wanted to answer that question that popped up.
The only thing I was going to say, there's a couple takeaways from here, because this type of an audit finding is fairly prevalent with respect to DCA audits these days, that the expectation that any documentation that's requested needs to be produced in precisely the format that's requested. And so I think it draws attention to me, one, having good ability to show your policies on record retention, that you adhere to your policies, being able to access data, whether through imaging or otherwise, when requested. But as David brought up, there are typically numerous ways to substantiate costs. In this area, subcontract costs, it could be the invoiced amounts, it could be other reports. And ensuring that you think more broadly about what those additional forms of supporting documentation that also, substantiate whatever the cost is, so that, there's a number of ways to get there, but it typically is an issue in just about every audit that we see these days. So making sure that you can, demonstrate good record retention and the ability to think more broadly about how to support the cost is very important.
And as we move on to the next slide, the other thing again is, and as David pointed out, this was the civilian board. It's not the Armed Services Board. It's not the Court of Federal Claims. So it would only be binding, so to speak, on interpretations of civilian contracts. The problem is if it's the only decision that's out there on the subject matter, and if it ends up being favorable to the government, I think DCAA is going to latch on to it for purposes of defense contracts as well. So on this next slide, sorry, Greg.
Greg, you had a question? You're on mute.
You're on mute, Greg.
Thanks. And I tried to respond in the chat box, but I'll just say it here as well. But the because you all are talking, it's FAR 31.201-2 on determining allowability. And then paragraph D, it's where contractors responsible for accounting for costs appropriately and maintaining records and so on and so forth. That's when it ends with the contracting officer may disallow all or part of a claim cost that is not adequately supported. So that's the phrase that often contractors and the government define that differently. So that's the only point.
We're already at 20-1, and I don't recall who had responsibility.
Yeah, let's just do a quick wrap on this
Yeah.
section. The next slide really speaks to where we see DCA focused. If you could go back one, sorry. In fiscal year 2021, business systems audits, again, some real-time audits, floor checks, we'd already talked about that, material reviews, billing reviews, TINA and defective pricing, cost accounting standards audits, and then continuing to stay current on incurred cost submissions. And I was just going to wrap on that. DCA's website does have some new additions of late. There are some frequently asked questions related to COVID for contractors, as well as government contracting officers and DCAA. And there is an audit alert on coronavirus, and everything that we see, is heightened awareness of DCAA asking whether you've accepted PPP loan proceeds, the extent to which you might have had REAs or reimbursement for CARES Act, whether it's paid leave or other forms of reimbursement, and ensuring that there's no double dip. We'll speak at the end to the extent we have time on, the forgiveness of PPP loans and how those interact from a cost standpoint. But otherwise, I think that that's it on the DCAA side. And I was just going to quickly touch on kind of other audit activity. There hasn't really been a ton of other audits. We already spoke a little bit about the DoD-IG report on contracting officer actions on question direct costs. From a GAO standpoint, there weren't a ton of meaningful reports. There were a couple out there that kind of took the pulse on how DoD was responding on the CARES Act side. Otherwise, all quiet on the Western audit front, I would say. The only other area I wanted to touch on a bit with respect to third-party audit activity, there's other agencies in particular rely more on third-party auditors to perform incurred cost audits. USAID being one of those, for example. We've seen a lot of activity where they use third-party audit firms. And one of the things that we've experienced with some of our clients is the volume of supporting cost documentation that's being requested, and the number of samples is higher than anything that we've ever seen before, and much higher than what DCAA typically utilizes. And so there's been some pushback, and we understand the guidance from USAID this year has been cut back or throttled a bit in terms of the amount that's being requested to be sampled. But just kind of a warning out there, again, record retention, being able to produce the documentation is pretty important, because the timeframes with which they ask for documents and expect them back is kind of ridiculously short, in my opinion. But that's just one of the other areas to see. And with that, I think we can flip over and start on the cost allowability matters. And I believe
Sure, I'll pick up on that. Thanks, Mary Karen. So really, in the cost allowability section, which is our third section with y'all today, we're going to basically focus on just two cases that came out, the DynCorp case and the Kellogg, Brown and Root case. Now, the DynCorp case was in the fall of 20, and it's out of the Armed Services Board. It deals with kind of this peculiar interface between executive compensation, compensation caps, severance, and standards for determining reasonableness that's in the kind of the front generic section of the cost principles. So this was a case where the DCMA determined that DynCorp improperly recovered costs of severance payments made to its former CEO that exceeded the FAR's cap on the recovery of compensation. Now, the board, in looking at this, I'm sorry, and they argue that severance don't meet the definition of compensation under, DynCorp said that the severance payments don't meet the definition of compensation under 31205-6P, as in Peter, which is the section that also deals with the cap for purposes of implementation. So they should be subject to the compensation cap. So the board said that, yeah, you're right. I mean, severance is not compensation. You look at the cost principles and how compensation is specifically defined, and severance is a different animal. And so the cap in and of itself would not apply to severance as severance. But it was more an issue of how the severance plan was defined. Now, again, they also said, we don't have any problems with the terms of the severance plan, but what the severance plan did was it was based on a salary plus a target bonus at 130%. And so although the board found that the terms of the plan were reasonable, it then turned to the FAR cost principle on reasonableness. And this is one area where I always say, everybody we all think we know this like the back of our hands, but you got to go back and look at the cost principles and read what they say. And the standard of reasonableness has these factors that are included, and some of them, you know, they rarely get relied on, and some of them don't make a whole lot of sense. But one of the factors in considering reasonableness is the responsibility to the government. And so it's the contractor's responsibility to the government is one of the factors. And basically what the board concluded was that the statutory cap that was enacted by Congress represented a responsibility to the government by the contractor. And so because severance in this instance was derived from a combination of compensation and a bonus, it was based on a multiplier of the salary, that the compensation cap had to play a role in the determination of what was reasonable for the severance that the CEO received. And basically this language at the very end is a quote right out of the case. And they say, the board says, the bottom line is unallowable salary cost used in a severance pay calculation results in unallowable severance costs, unallowable in, unallowable out. That's exactly the language that's in there. Now, this, of course, is dealing with a highly compensated individual at DynCorp, but it's not limited to compensation for CEOs. You have to think about what this analysis is because of the fact that the cap is playing a role in this. And you know, you'll recall that originally the cap only applied to the highest 5 compensated people in the company, and then it was the 5 highest compensated people at business units. Then it was to everybody making over a certain amount of money. So the concern about this is if you have employees whose compensation would otherwise be over the cap, and you have, excuse me, and you have a severance plan where the payment of severance is premised on some kind of multiplier or factor of salary, then all of those employees are going to be at risk of receiving what's going to be, you know, unallowable severance pay under this theory. Now, this decision just came out. I don't know. I'm presuming that DynCorp is appealing to the Federal Circuit because I don't think the board really thought about the broader implications of this decision. And I think that I'd be surprised if DynCorp didn't go ahead and pursue this at the Federal Circuit. So I suspect that there's more to come on this. But in the meantime, you know, compensation is always a subject matter in ICSs, and I think that this will be a highlight with DCAA going forward to the extent they can take advantage.
David?
David, yeah.
One quick comment. I don't know whether the decision would have been any different if this were tried in the courtroom with live witnesses. My memory is that this is a case that was decided on stipulated facts. Anytime that you try a case on the record, you lose some of that ability to add the color and additional support. And it struck me that this might have been a case where having live witnesses could have helped.
Yeah, I think well, it's possible in terms of the color and the, you know, sometimes, especially as the judges on the board have all shifted and we've got a lot of new judges. And so there's experiential things that are going on in terms of appreciation of broader issue. But I think that this boiled down to a fact to law kind of application here. And that's probably the way it came down. I'm sorry, Greg, were you raising your hand?
No.
It's Brent was.
Yeah, I just wanted to comment that I thought that my takeaway as a non-lawyer, because there's lots to take away from this case, is the judge said severance is not compensation. So, but ultimately came back around to getting to the same answer as if it was.
That's right.
So,
Yeah, yeah.
it seemed like a very circuitous path to a simpler answer, but
Well,
but-
Brent, that's a really good point, because I will tell you, as a practitioner at the board, I'm seeing a shift in the way that the board approaches things, as opposed to the judges who had been on, as I mentioned, there's been a whole transition just in the last few years. And I notice a different approach to analysis. And I think that's part of what's going on here, because in the end, they were looking at, well, let me look at the particularized language. It boils down to this crazy, responsibility to the government language that's buried in that reasonableness 4 factors, and then nobody ever looks at, and have never been applied. So that was when you mentioned about the circuitous route, that's kind of how they got there. And so they were able to hook it into the regulations. But I agree, it's they do say it's not severance, but here, I think they were just driven by the fact that there's a cap and what's reasonable. Mary
Yeah,
Karen.
the only thing I wanted to add, it's good that it has been defined as not being compensation, because if it's paid in the same period of time as compensation, it would have to be reported as part of that total. So theoretically, if they were over the cap with the comp, all of this would be unallowable. So I think it's helpful to contractors going forward, as they're preparing whatever statistics or analysis of compensation for their annual audits, you could exclude severance. I think it was a little ambiguous previously. So that's a
Sure.
good
So
thing.
why don't we move on to
Yeah.
slide 16, and we'll talk about the KBR case, which also interestingly deals with the subject of reasonableness. Now, this isn't a straightforward cost allowability question, because this arises from the submission of a REA, a request for equitable adjustment. And for those of you who've been keeping an eye on this, KBR has been going back and forth between the Court of Federal Claims and the Federal Circuit on this subject matter for years now. But bottom line is they had a contract with a delivery order for trailers. They subcontracted with a Kuwaiti firm, and KBR alleged that the government breached the contract by failing to provide force protection. You may remember that was an earlier version of this case. So it resulted in idle trucks and drivers and additional loading, and so an additional cost to KBR. So they submitted an equitable adjustment with all of the subcontractor costs, and the government looked at the KBR's claim and they said, well, we're only going to allow 3.7 million of your $51.3 million claim. So naturally KBR appealed this. And if we can go to 2-slide deal. So if you go to 17, please. So they first went to the Armed Services Board, and the ASBCA denied KBR's appeal. So that's for this big, huge extra chunk of money. Because they said that, and this is why it comes up in the cost allowability area, that the settlement costs with the subcontractor were not reasonable. So again, they were looking at that reasonableness standard that's in the front section of our Part 31, and to use it as guidance for reasonableness. And they said the equitable adjustment was based on the subcontractor's estimates rather than on actual costs. They said that the model was unrealistic, it was inconsistent, things like it assumed a perfect world. They assumed that absolutely everything that would happen happened. And so that built up the cost of the claim, as opposed to something that would look at what actually happened. And things are not in a perfect world. And so they didn't fine tune things and consider that this is what the cost should have been. But when I say that it looks to the reasonableness standard, this one looks to the element of the prudent person standard. In the reasonableness standard and the cost principles, it would, what would reasonable business people, it's almost like the standard that you find in the definition of cost of pricing data, which is, what would reasonable people consider to be a reasonable cost. And they didn't feel that a prudent person would have assumed a perfect world when coming up with the estimates. And so this then goes to the Federal Circuit, and basically what they did was they rubber stamped the Armed Services decision. They did reject the government's position that KBR was required to submit the actual costs incurred by its subcontractor. They only needed to show that the costs were reasonable, but they followed the same analysis and said, well, yeah, the board is right about what they looked at for determining reasonableness, and the failure to collect actual costs bears on that interpretation. Not that it's a separate requirement. Ultimately, what's troubling about this is, in the end, the Federal Circuit should have actually just remanded the case to the board for the determination of what was reasonable. Because what the Federal Circuit says in part of the decision is that part of the reason why it came down to this is that KBR failed to demonstrate that the costs were reasonable, but that wasn't what they were litigating. They were litigating the question of whether that standard should even apply to them, as opposed to whether or not they met that standard. And so all in one fell swoop, the Federal Circuit threw all of that into the case and said, not only does the standard apply, but you didn't meet the standard because you didn't show the proof. And so prudent business person, sorry, KBR, you don't get to recover the money. And I see that someone has joined our panel who's not on our panel.
All right.
If
Let's
there's any
move
other
on.
thoughts there, we could move on to our next area, which is, I think,
Yeah, I think the CAS, and
Yeah.
Brent, are you going to lead us off, Brent, on the CAS developments?
Sure, this will be quick for you, Paul. We'll move past the administrative stuff and get on to the cases. So here's just well,
whoop, whoop.
yeah, there we
That
go.
was fast. Brent.
That is super fast.
Right.
Very fast.
See, this is the reason why the cost and pricing panel is always the best one, because we're so much fun and we keep you on your toes.
That's right.
We'll keep this going. So the CAS board continued with really its exercises that it began in earnest in 2019, which is to follow Congress's direction to see if we can conform CAS and GAP. We kind of talked about that in last year's panel. There's some different points of view on how that could occur, but the CAS board seems to be settling on its reconciliation of CAS to GAP. Rather than overall conformance, but we'll see where it leads. It does seem to be leading in a direction that I think will be acceptable. Whereas there's just big elements of CAS that can't actually be stripped out, and I think that's where the tea leaves are taking us. In March, we got some updated guiding principles. There was a lot of commentary on last year's statement, staff discussion paper. And I think the CAS board really took a lot of the commentary to heart. Some of it was bigger picture. Others were more narrow on the standards that they reviewed last year, 408 and 409. So we got a new set of updated guiding principles in March 2020. In September of this year, we got a new staff discussion paper, this time on CAS 404 and 411. Also, two generally non-controversial standards that seem to be pretty well aligned with current generally accepted accounting principles. Seemed like some of the sticking points here is the express requirements to have policies, which is not necessarily are expounded in GAP. So we'll see. I think industry is like, well, of course we're going to have policies for these things if we're a CAS covered contractor. We'll see if they retain some slivers of these standards, but it looks like that's trending in a good direction. We also got an advance notice of proposed rulemaking for the conformance of CAS to GAP on operating revenue and lease accounting. These are particular areas that, rather than toiling away in the standards, these are things that have changed recently in GAP that have to be harmonized with how CAS uses them. So this was the CAS board's first attempt, and I think there was a lot of comment letters from the industry associations just went in on this. think the general gist is there's some finer points to do some tweaking with, but generally going in the right direction. And anybody have anything more to say on the CAS gap reconciliation thing? I think in our practice session when we met last week, I called there's a lot of bun and not a lot of beef in these at this point. And that's not necessarily a bad thing, because this is an opportunity to actually get rid of some onerous government regulations. Right now it's the low hanging fruit. So I'm just going to keep my fingers crossed on that. And the last one's really just a public. Go ahead, Greg.
I'll just keep my fingers crossed as well. I mean, it's a positive development when the regulators are trying to simplify things. And GAP versus CAS, they are different regimes, but there's a lot of overlap, and trying to simplify that. That's a great. I'm pleased to see that development.
Right, and some of us, as we can be regulation haters all day long, but there are some elements of the regs that are actually beneficial and helpful for contractors as well, just to keep the playing field even. So we don't want to throw the good out with the bad as well. So there is some merit to the reconciliation exercise rather than the wholesale trash candidate. And the last piece.
Do you see the prospect of any of the standards going away?
Entirely, maybe, Paul. I mean, I think CAS 411 would be a great situation. Yeah. I think there's a CAS 408 would also be another one that we could chuck in the circular file. But there will likely be some minor elements, more nuanced elements of some of the standards that survive while chunks get chopped out. How that will make CAS read will be certainly different than they're pretty comprehensive standards right now for the subject matter that they're dealing with. So now we have kind of piecemeal requirements associated with the subject matter. It'll be different, and we'll see how it all takes shape. We're not there yet, though, and we haven't even seen an advanced copy of what that might look like. The last piece here that we just released in December. There's some copies floating around. Certainly let any of us know. We can send you a copy, but DCMA just issued its new, its revised CAS administration manual. I think the general gist of that is it's pretty good. Again, there's always going to be something in there somebody can find something a little bit disagreeable with, but the general gist is if you really want to know what the government or DCMA believes its roles and responsibilities are with respect to administering CAS, which is disclosure statements, cost accounting practice changes, and the like. This is their playbook, and you might find it interesting.
And that's DCMA Instruction 2201, if anyone's looking at it, Cost Accounting Standards Administration.
And you want to make sure you're referring to the right one, the most recent one. So that's what they're referring to.
Awesome. All right.
That's it for this slide.
Okay, so if we can move on to 20. So the rest of our discussion on CAS is going to involve two cases that both of them came out of the federal circuit. I'm sorry, one of them came from the federal circuit, the other the Services Board. And I'm going to take advantage of the fact that we've caught up on time because the Boeing case, I think, is really probably the most critical case that's come out this year in the space of accounting, cost, and pricing. I'm going to give a little bit of background, so especially because this is a subject matter that's been near and dear to my heart. This has to do with the ability to offset multiple changes in cost accounting practice when, so if you have multiple changes that occur at the same time and you do a cost impact, and some of them result in an impact to the government, but some of them result in a benefit to the government. Historically, contractors had been able to offset the benefits against the impacts, and it would either reduce or eliminate the contractor's liability economically because of the changes in cost accounting practice. But then in 2005, the FAR Council instituted a whole new set of regulations in FAR Part 30. And basically one of the elements in the cost principles was you can't do this offsetting anymore. That's basically what it boils down to. And so there were a series of cases that started coming out earlier in the teens, and Boeing had a case where they brought it to the Armed Services Board, but all of their changes predated the 2005 change in the change to the FAR. And the board in that case held that, well, gee, there was no regulation or practice dealing with this, no regulation dealing with this, but there was ongoing practice and understanding by the parties that you can offset. So the board held that prior to 2005, it was permissible to change offset, to offset changes in cost accounting practice. Then about a year or so later, and I guess I want to say like in 15 or so, I had a case for Raytheon where we had multiple changes in cost accounting practice, and some of them predated 2005, some of them overlapped or postdated 2005. And the board said, well, we're going to rely on Boeing for all of the cases that are pre-2005. And we pointed out, and this is what was very frustrating because the board ignored it, there's actually in the CAS regulations, there's a section and the administrative history tying to particularly the materiality provisions that says that you are supposed to apply these to a cost impact, and one of them says it's offsetting. So, and we also argued that it was improper for the FAR Council to do something that was in the jurisdiction of the CAS board. Well, long and short of it is that if you read the decision, the judge came up with his own theory altogether that none of the parties even argued, and then ultimately decided that, well, gee, the director of OFPP who chairs the CAS board is also on the FAR Council, so he had to know what was going on and didn't complain, so this is okay, and ultimately decided that pre-2005, there you can offset, but after 2005, you couldn't offset. The other good news about the Raytheon case is that in the end, all of the decisions got, all of the costs got decided for other reasons. And so the decision about the changes in cost accounting practice by law ended up becoming dicta. So it's not technically binding, but on the other hand, it's an expression of the ASPCA's point of view. So fast forward to about 2019, 2020, and Boeing now is like, okay, we've got the same issue again, but now it's for changes past 2005. We're not going to go to the Armed Services Board. Let's go to the Court of Federal Claims. And they decided to go, and David will appreciate, I'm sure he'll make a comment, but he'll appreciate this, that they decided to go with a firm that does constitutional law. It's like, you know, they were taking a completely different spin on this. And they basically said that you breached our contract by incorporating FAR Part 30 provisions into the CAS clause, which are not included, and you that this was an illegal exaction under the Constitution, and so that under the CAS, because of the CAS statute and how the government can excise money from contractors. And the Court of Federal Claims issued this incredibly long, convoluted, you know, so Brent, to your terms, talk about convoluted decision that was, I practiced before the court, so I got to be cautious here, but it was really pretty mind-numbing. And
that was cautious.
Yeah, I know.
I second that, though.
Right. Thank you. So what was very, very troubling about this case was that the court basically said that the provisions of FAR Part 30 were incorporated by reference into the contract, and that Boeing, as a significant contractor, was educated about these things and should have known, and so they should have objected to the application of this prohibition on offsetting when they entered into the contract to begin with. And why I say that's especially troubling is because you could read that to mean anything. If it's going to be incorporation by reference, that doesn't just mean that it's FAR Part 30. That could mean that there's some completely different subject, and FAR Part 25 is incorporated into your contract, or FAR Part, you know, whatever. Give me a section that's regulatory, And then the other part was that the court found that the CAS statute, that Boeing hadn't presented a statute for purposes of its illegal exaction argument. And so basically denied everything. So it was also a way not to get to the merits of the case. So the case then went to the Federal Circuit, and that's the case that came out this year. And you'll see I've basically on this slide delineated everything that's happened at the Court of Federal Claims. So if we move on to slide 21, the Federal Circuit reversed everything. They reversed the entirety of the Court of Federal Claims decision. What's really important here is this concept about incorporation and the needing to challenge something at the negotiation of the contract or the award of the contract. They said that Boeing could not waive a challenge, in Boeing, they could not waive a challenge to FAR Part 30.606-832, where the contracting officer had no ability to waive the mandatory regulation. So it says to the contracting officer, thou shalt do this. And it couldn't say how Boeing could have challenged the regulation prior to entering into the contract. And the court said they couldn't have brought a bid protest. So there was no way for Boeing to challenge this. And there was no way for the contracting officer to waive it because it's got mandatory language. So they said that the Court of Federal Claims was completely wrong on this analysis, and they sent it back for remand to start from scratch. And then also on the other issue about the illegal exaction, so the court also said that Boeing's attempt to recover money already paid to the government conferred jurisdiction for an illegal exaction claim without the need to identify a money mandating statute or regulation. So the Federal Circuit also said that the analysis by the Court of Federal Claims on the exaction was completely off the mark. So basically what the Federal Circuit has done is thrown the entirety of the very long and convoluted Court of Federal Claims decision out the window, and it starts from scratch. So now what we need to wait and see is a decision on the merits of these issues. We don't know what the court will argue. We don't know, I mean, what the court will hold. It's still possible that for a different reason, the court can decide that, yeah, it was fine for the FAR to prohibit offsets, or it may, under these differing approaches to the case, decide that there isn't an ability to prohibit offsets. You have to allow offsets. So either way, I think this case is gonna, unless the parties settle, which I don't think is likely, because I think Boeing is looking for a decision on this because everybody wants one. This is probably gonna find its way back to the Federal Circuit, because if Boeing, if the Court of Federal Claims decides that you can offset, then you have a conflict between the Armed Services Board that says that you can't, and the Court of Federal Claims that says that you can. And so then the Federal Circuit's going to have to decide it. Or if the Court of Federal Claims decides for a different reason than the board, or the same reason, that the prohibition on offsetting is okay, I would imagine that Boeing would still appeal to the Federal Circuit given its successes here. So this is definitely a case to keep your eyes on, because it's always been, I mean, it's always been a significant issue for contractors.
I'll just mirror agree that it's been a significant issue for contractors. There's lots of contractor claims, I'm sure, in the pipeline, so to speak, waiting for a decision here. And this affects a lot of money and a lot of contractors.
I don't know if anybody else has other comments. I'm keeping an eye on the clock. The next one I'm going to skip through pretty quickly, because the Northrop case is just it's a CAS pension curtailment case. I'll just have it here because my point on this one is that there's been a lot of activity under CAS 41350C12 even now, and I'm seeing, frankly, I've got a whole slew of pension curtailment cases going on, which seems to be the thing. And this is one where, I mean, it's not terribly interesting because it has to do with the actuarial assumptions and what was appropriate and so forth. But to keep us on track with the time, I just wanted to alert everybody to this case. We've got 2 slides on that. So 21, I'm sorry, no, just 1 slide on that. So that's slide 22, oh, and 23. So if you can move to 23. So basically the bottom line is that the board found in favor of Northrop on this in terms of the assumptions they used and so forth. So I'm going to turn it back to you, Mary Karen.
And
Actually, I think
Oops,
it's,
sorry.
Greg, you had a quick comment?
yeah, it is quick. Yeah. And I'll just say, since we're talking about the CAS, I'm finding myself working and know of many False Claims Act cases related to the pooling and allocation of cost as governed by FAR 31, but especially the CAS. So and it's a common denominator seems to be a non-accounting personnel sees, and I think we can all agree this pooling of cost into accumulation of cost into pools, and then allocating, whether it's allocating home office overhead to segments or segment cost to final cost objectives, or however it's being done, it is confusing. And so these people, look at it from a distance, they don't understand it, think it must be wrong, and they file some kind of whistleblower lawsuit related to it. So just, I don't have a conclusion from that. Just be aware of that. Just be aware of that. That's the only comment I had.
Okay. Let's give David a chance.
Next slide.
Get the benefit of those 100 days in the courtroom there.
Yeah.
I'm glad to be out today. Truth in Negotiations Act. Some people quibble over the title, but the title of 10 U.S.C. 2306A is still Truth in Negotiations. So next slide. We're going to be talking about the alloy surfaces decision a bit today. There's 2 things unusual about alloy surfaces. One, it's a published decision. If you look over the last 10 years, we've had very few cases to come out. In fact, 3 cases by my count. The second thing that is unusual is that most of the defective pricing published decisions are one issue, like Symmetrics was disclosure, Lockheed Martin was damages. Alloy Surfaces has one of the largest collection of issues decided on defective pricing in the last 15 years. And it's notable when we were talking about sustention rates that DCAA is claiming, in all 3 of these decided cases, DCAA and the government got nothing on defective pricing. Let's go to the next slide. I'll give you another cut on the sustention rate. These are cases I know about. If we pulled all the experience on this panel, I think we'd probably come out to about the same thing. When you look at litigated cases that have made it to the ASPCA, which does 99.5% of the defective pricing cases, the record of sustention is less than a penny on the dollar. When I looked at the sustention rate from 1990 through 2010, it was about 11% for decisions back at that time, but the rate is going south for DCAA these days. Let's go to the next slide and look at some of the—
Yeah, David,
Please.
I was just going to interject for a second on your prior slide. I think the prior slide.
If we can go back 1 slide to slide 26.
Yeah,
Thank you.
I think the one that was the 5994, it was either that one or the other one where it says resolved at a very low percentage, was a case I had where we ended up with we were able to demonstrate that it was that the cost pricing data had been provided and that there was also a statute of limitations issue. So we ended up with a nuisance resolution. So I don't recall just off the top of my head what which the board number was, but that's probably that's the reason why it says resolved in such a low percentage, because I remember we just paid a very nuisance amount.
Yeah, I can say that the third one, 3% was Pratt & Whitney, and the fourth one was DRS Technologies. So you can add yet another to the pennies on the dollar. When you get down into the thousands, litigation costs wipe out the settlement pretty quickly. So.
Well, actually, Actually, it wasn't one of those, so you will have to add another one in. Sorry. Thanks.
Great. If we can go to the next slide, slide 27, some practical pointers coming out of the Alloy Surfaces decision. Let me see how quickly I can go through. Please jump in if you have additional points. I litigated this case, so I hope my panel members will be gentle with me in their criticism of it. The first one, 5 points of defective pricing. Nearly everybody on the webinar today is familiar with that. First, it has to be cost or pricing data. Second, it has to be reasonably available. Third, not disclosed or known to the government. Fourth, the government relied upon the data. And fifth, the data caused an increase in the price. Two practical pointers out of this. First, you should fight on all of the points you can possibly reasonably fight on. You should attack all 5 if you can, because you only have to win on one, as the board said in Chu Associates. If the government loses one of the 5 points, they lose the entire defective pricing claim. The second practical point is that there is a synergy between these points. That was certainly true in the Alloy Surfaces case, as some of the facts on cost or pricing data also helped us on reliance and causation. They work together to allow you to win a point you may have otherwise had some difficulty with. The second point, negotiation story. The negotiations, as one board decision said, is the heart of a TINA case. Every TINA case has a story. Sometimes, like in Texas Instruments, they agreed to use the average or rolling average cost. And DCAA, of course, departed from that and said, well, let's look at cherry pick one of the purchase orders. In Alloy Surfaces, the negotiation story was that Alloy Surfaces have been coming down the efficiency curve over the past 2 or 3 years, but then they were asked to ramp up to triple production, requiring them to open 2 new plants, qualify a slew of new automation equipment, and bring in over 200 new workers. The effect of that was to render the old cost data largely irrelevant, because they were going to be bringing in less experienced, less efficient people to do it. So you always want to look at why the parties got to the handshake, that negotiation story. The third point on cost or pricing data, this is one area where the Alloy Surfaces case does push the boundaries on the law. On unreliable data, there's only 2 or 3 cases in the last 60 years that say that cost or pricing data is so unreliable that it is not cost or pricing data. It does not meet the standard for reasonable buyers and sellers to use it to negotiate the cost. The second, a point that we've seen often, is intertwined judgment and fact. As you know, if you have that, like a vendor cost analysis, you have to reveal the entire vendor cost analysis, because it has some facts like purchase history. It also has some judgment, such as the buyer judgment on what you're going to get. In Alloy Surfaces, the judge said, here, the facts and the judgments are intertwined themselves. They are used in combination to come up with this 4-digit number for how long it takes to do the work. That is a new angle on cost or pricing data as well. Agency reliance. A lot of this is old law. Contracting officer can't rely upon the certificate. This was that unusual case where the contracting officer actually admitted in the courtroom that she relied upon the certificate. But it also resurrected some old law, Luzon, Stevedorian, and others, that if the government relies upon a price analysis, that rebuts reliance on the cost or pricing data. And here, the agency, the Army, had been very close to the manufacturing process, actually walking the line and developing a very sophisticated technical analysis. The fifth point, government knowledge. we didn't win on that. That was one of the 5 points we did not win. But there was government knowledge up and down the manufacturing line to the point that the government engineers knew how long it would take for particular machines to produce these particular flares. That then helped us on cost or pricing data. It also helped us on reliance and causation. Finally, on the litigation strategy, this is one place where I really appreciated what the Alloy Surfaces did. They brought me in early, back right after the draft audit report, and we were able to put together a substantial advocacy paper up front. That advocacy paper then became the roadmap for the rest of the litigation. In fact, I used it in the courtroom to go down point by point. Did you consider this contracting officer? Did you consider this? And the answer was repeatedly, no, no, no. So let me stop there. I suspect that there's other comments on Alloy Surfaces.
Hey, question. Did you find that the judge maybe felt compelled? Let me take a step back. As you pointed out, all you need to do is be successful on one of the 5 points in order for the case to go out the window. Did you find that the judge felt compelled to, maybe for purposes of not getting appealed or otherwise, render decisions on so many elements, or did you think there was anything else driving that?
I'll say this, I'm unclear because there's, with Judge Peacock stepping down, there's really no judges with experience in this area. I think one of the factors was that the fact pattern of this being a new production line cut through several of the issues, including, is it cost or pricing data? Would you rely upon it? Would it cause an increase in the price? And so there was a synergy running through multiple points. But if I were a judge, I might consider exactly the point you made. Let's make this appeal proof. And it is a very factual decision that would make it tough to take it up to the federal circuit.
Hey, David, can you give a little more of a description of the nature of what was being asserted? I mean, I feel like we got some of the edges that there was a lot of factors that went in, or some kind of a change that caused the price to not be consistent with historical cost or price information. But I'm not sure I understand the full nature, or for our audience, kind of the full nature of what was being asserted, the fact pattern.
Sure. This was a production line for making flares that were very popular in Iraq and Afghanistan. They were using a lot of them. There was an estimate that was used by the company to track how many hours are we spending, or portions of an hour, on each of the 13 steps of manufacturing. And this report had the estimates down to the 4th decimal point. Looks very much like cost or pricing data. They had the same on material costs, how much steel, how much titanium, and so on. There were a series of delivery orders, and the last delivery order, right at the time of the handshake, was at the most efficient point of the production line. And DCAA said, you did not disclose this particular delivery order and the hours on it. If we had that, we would have negotiated a lower price. At the same time, the Army Technical Engineering team was walking the production line. They were estimating to the 4th decimal point on each of these 12 or 13 steps of labor manufacturing, and also on each one of the elements that went into the flares for material cost. So it was a debate about whether that last most recent delivery order at the peak of efficiency was the best predictor of the negotiated price. Ultimately, Alloy Surfaces said you can't use it because it has judgment in it, and they did not disclose it. If it had been disclosed, obviously we would have never got to the point of litigating. Greg, you're mute.
Yeah, thanks. Frank. I like your comments about this case very much. A related subject. So DCA does these post-award audits, also called defective pricing audits. And I've heard of some of those where they look at like 3 documents, maybe the price negotiate or pre-negotiation memorandum, the proposal submitted by the contractor, and then they say, you know, here's some information. And they get tipped off and they look at just very few documents, and then they issue a report, as opposed, and as you know, as the panelists know, there's a lot more disclosures than there's just what is in the proposal itself. Anyway, are you seeing, maybe those don't rise to your level, David, I mean, maybe, my guess is you see a lot of DCA audit reports on this subject. If you could comment on that.
Sure. I'm repeatedly seeing instances where the DCA auditors look at a few data points, a few items. Sometimes they look at the purchase history since then and then track back to see if that subsequent purchase order was disclosed. But there's 2 things that they're not doing. You know, they are not going into depth on the technical analysis and the pricing analysis and the details that went into them during the negotiations. And also I'm seeing agencies that are deleting or destroying documents, and DCAA looks at their files and say, we found no documentation of disclosure. Well, of course you didn't, it was destroyed. So I'm seeing very superficial audits. And one other thing related to that, of the cases I've litigated in the past 7 years, repeatedly the contracting officer, the PCO, has never done a defective pricing case. The contracting officer that issued the final decision has never done it. The pricers have never done it. And even the DCA auditors, most of them have never done a defective pricing case. One of them that was involved taught the one that had never done a defective pricing case. He was the auditor in the Lucky Aeronautics case that zeroed out at the board.
Hey, David, I have a question for you. So looking back, what advice would you give to companies about the level of documentation that they should put together in support of the negotiation, you know, their own price negotiation memorandum and the documentation of what they consider to be cost or pricing data? You know, any lessons learned that are wise to inform companies about how to document what, you know, their assessment at the time of negotiation?
That's a good point about the price negotiation memorandum. Anytime a contractor can put one together, they are most likely going to be more detailed than the one that the government contracting officer put together. And that's going to be helpful in a number of areas in identifying what was disclosed and also what was relied upon. The negotiation story.
Especially if the government's destroying the pricing analysis or technical analysis, at least retaining your own is pretty important.
Absolutely. The other is, you know, try to capture your negotiation library as soon as possible after the negotiations and preserve it in a place that you can find it somewhere down the road. These cases go on so long, 6 years, 10 years, 15 years, that there's turnover, a lot of turnover in the government, but still turnover in the contractors too. Maintain your library of disclosures in a place that is readily available and you can turn over first, you know, when you have an opportunity in response to the audit. No, we disclose this. That's the best case. Make it go away before the lawyers are involved. But the second best case is, you know, if you do get the audit report, then put your story together based on your library of the negotiations.
I would say
I would echo that point because oops, I'm sorry, we were talking over each other. I would echo that point because I think Tina is raising its head. To David's point earlier, there have been so few cases, but I'm seeing more and more of them coming. And to one of David's other points, about the burden of proof, it's a government claim, so technically they have the burden of proof, but it's a little bit of a backward scenario because you're proving a negative. It's the absence of cost of pricing data. And so I would definitely echo what David said about capturing and retaining the data, because the other issue is I think people are under a presumption that the statute of limitations clock starts to run at the date of the certificate is submitted. And there's no, excuse me, there's no definitive case law really on statute of limitations with defective pricing. There's been a couple. There's a Lockheed Martin case a while back. And so I don't think you need to take it I don't think contractors should take it for granted that, oh, it's been more than 6 years since I submitted the certificate, so I don't need to worry about that anymore. That's not a wise approach to take.
Brent?
Question for David. So I think we've all recognized that understanding of what Tina requires of all the parties involved has atrophied greatly over the past 15 or 20 years. But we have seen that apparently DoD DCMA is setting up a group to start handling these matters on behalf of the PCO community. Have you had any experience with that? Early thoughts, is it blind leading the blind, or is there some folks involved that really do have a handle on what the requirements are? And two, do you see any kind of shadow of that at DCAA?
That would be smart for them to set up some people that have experience. I have not seen it, but if they're doing it, I applaud that. The level of expertise that I was seeing is, ground zero. And there's very few people that are around to teach them how to actually do a defective pricing case.
In kind of a related subject, there was an undersecretary of defense for acquisition who's no longer at the DoD, who thought that I think 1% of what the U.S. government paid was defectively priced. And somebody can check me if you remember that differently. And I've never seen any statistics that even any statistics like that. Nobody else either. Okay.
Well, I remember Mr. Assad's assertion there, but I also remember laughing out loud at it.
Yeah. But ripple effect, 5 years later, we're seeing all these defective pricing audits, and that's the only thing I can point to that started this trend is his opinion.
Well, no, I think Greg, it's because DCAA decided that they were all caught up on ICSs. And so, because actually they said that, a couple of years ago, that was what they were touting, was we're all done with ICSs and our new focus is TINA. Yeah. So I think that we're going to be seeing more, I'm certainly seeing more uptick in that space. So I think that's going to be the case. Mary Karen, I don't know what the time is with our last section, because
we have about 10 minutes.
Yeah.
So
let's use up all our time so Alan can't ask us any questions.
The only thing I was going to add on, and Greg, I'm sure you can attest to this, with respect to really compiling your negotiation library, as David was asserting, that's not only helpful, and preventive in the terms of defending yourself in the event of a, Truth in Negotiation Act violation, but we're seeing a lot of REAs, terminations these days, and the ability to really demonstrate what the assumptions are that underlie, the estimates that were developed on the front end that went into negotiations is extremely critical when it comes downstream. And it's often hard to find that, those documents at a later point in time. So I think for a lot of reasons, just really fully documenting your assumptions and pulling together the library on the front end is really important, as David brought up.
Let me make one plug for our auditing friends here, Mary Karen, Greg, and Grant. You should As soon as you get the draft audit report, you should attack it immediately, and then you should attack it again when you get the final audit report. You should keep attacking it, because all of that cost up until the final decision is contract administration. The more of that you can do before you get the final decision, the more you're going to be able to recover.
Thanks, Dave. Thanks, David. I'm going to replay that recording of you saying that over and over and over again.
There we go. All right, let's do the last slide, the last topic, and then we can, to the extent there's any Q&A that we need to address. So just just some words about the CARES Act considerations. And as we've kind of talked about, there is a lot of guidance out there to DCAA relative to, contractors' potential reimbursements under Section 3610 or PPP loan proceeds. And really, this is the year when a lot of those loans are going to be forgiven, and people have to determine, whether a credit is going to be due the government, because as you are aware, there can't be what's perceived to be double dipping. So if you are able to get forgiveness of PPP loans, and those costs would otherwise be charged as direct or indirect costs, there could be a credit that's going to be due to the government as a result of that. And because most of the activity, that underlied the request for reimbursements occurred last year, and the forgiveness occurs this year, there's going to be some ambiguity around how that credit is going to be provided back to the government. There's not a lot of clear guidance today. One thing I would say is make sure your records for the types of costs that were used for PPP loan request purposes, or that went into, request for equitable adjustment or other reimbursement under Section 3610, that those records are clear and retained, and specific charge codes or otherwise indications of exactly how those amounts were determined, because the credits are going to have to be given back kind of consistent with the way that those costs were identified. And, whether it's a direct cost or an indirect cost, there's not tons of guidance out there about credits. There are some cases out there, but essentially, the way that the costs were charged in the first place, to the extent that they are now reimbursed, then the credit needs to go back in a similar fashion, primarily on flexibly priced contracts. So, to the extent that fixed price contracts were already negotiated prior to that point in time, they shouldn't be affected. But it does have a bearing even on disclosures from a Truth in Negotiations Act standpoint, that you may have been in receipt of some of those funds that could potentially affect, that they costs may be reimbursed. You don't know at this point in time what it's going to be. So there's a lot of ambiguity, a lot of questions without answers, but I predict this will be another area next year that we'll be talking about how those credits are determined. Audit reports are going to come out asserting that potentially not enough was given back. So, there should be care taken there. I know I'm working on an article about how to address the credits, and I'm sure others have a lot of questions. I don't know if anyone else has any input with respect to that, but I'm just predicting it's going to be a large area from an audit standpoint over the next year during in-car cost audits and DCA audits. Yeah, Brent?
Yeah, Mary Karen, you and I talked about this, briefly, and each contractor's scenario is different with respect to PPP loans and forgiveness, and ultimately how, if there will even be a credit necessary.
Right.
It really comes down to what are we asking forgiveness for. Remember, it is for payroll and other types of allowable expenses, with the extended range from 8 weeks to 24 weeks that usually wound up with a lot more payroll than what your loan value was. So just be selective. DCAA's guidance that came out in December even recognizes that, well, maybe, the cost type contract labor wasn't even what was forgiven.
Right.
Because it really does pretty closely align with what the credits cost principle requires, which is, if you paid a cost and you got reimbursement for it, that's where the credit goes. So be very specific, not general with your costs, and including to the extent that you're asking for forgiveness for payroll dollars for direct and indirect, and that can make indirect cost rates really goofy if we're not careful about how we do that. So just ask for forgiveness in proper proportions so your rates don't get all goofed up. And I'm sure
Right, because
you'll
I'm
have
seeing
that in
contractors kind of jump to just do forward pricing rate requests or provisional rate requests that show a big credit for the amount that was received. And that's probably not the best way to go about doing this, because one, rates that are negotiated aren't going to be reflective of what your actual rates are going to be. And that isn't necessarily how the credit has to be given back. So that may be to the detriment of the contractor.
Yeah, definitely want to urge, to the extent you're affected, but think it through very carefully.
Yeah, and one question that typed in the Q&A, Mary Karen, was T&M contracts. Would they need to give a credit for PPP on T&M contracts?
And theoretically not on the T side, since that's a fixed hourly rate, but on the M side, to the extent that G&A is applied to the materials cost, and if some portion of those indirect costs that comprise the G&A pool theoretically were reimbursed through PPP loan forgiveness or some kind of an REA, then theoretically some portion of that would have, gone through and been allocated to the M portion and would have to be provided back. But again, it doesn't have to be through a rate reduction. It could just be through, a year-end true up to an invoice. There's a lot of different ways to get to the right answer. But theoretically on the M side, on the G&A piece, if some of that labor was claimed for PPP loan purposes, again, or REA, then theoretically there might be a give back.
And there was a question online as well that's going back to defective pricing. So should I tee that up, or are we finished with
Sure.
this? Yeah, and so this was just the in the context of defective pricing, the record retention practices, and as you all know, there are record retention requirements for government contractors, and the kind of the interplay of those. And my initial take is, yeah, a company needs to comply with those, but if they can't establish that certain information was disclosed, even though they've retained all those records, that's still a problem. It was my initial answer. David or others?
That's still a problem. I mean, ultimately, the government has the burden of proof, but it's in the interest of the contractor to make the audit go away as soon as possible. And by retaining the data, that's your opportunity to kill it before a final decision. If you haven't retained the information, then you are at the mercy of whether the government retained their information, and then you're going to be fighting that rare Whitaker case when nobody has the evidence. Who wins? Theoretically, it's the contractor, but you don't want to be hauled through litigation to get there.
And I would just say, think about REAs and terminations. They typically happen the last 5% of an award. So for a lot of reasons, it makes sense to retain some of these records even longer than what your record retention policy might say.
There was also a question that was posed, it was directed at me about something that I had said about the statute of limitations relative to TINA. And it tied into the question tied into the record retention. I don't think you can't necessarily assume that the obligation, the 3-year obligation after completion of the contract somehow implicates the ability of the government to continue to pursue an action under defective pricing, because ultimately it's going to be, when did the government know or have reason to know of the basis of its claim? And so, on one extreme, contractors would argue, well, we submitted our cost and pricing data certificate and the data, and so you had everything you should have known. But then the case law has been evolving in other areas, not related to TINA, that says, well, it's not until the government gets certain information. What is it that they became aware of, and when did that happen? And so I don't know that you can necessarily, I'm not going to say anything definitive, but I don't know that you can necessarily say that, okay, I only was obligated to retain documents for 3 years after completion of performance, so the clock had to have run out either then or started to run then. So it's a different standard altogether. So I think what you're hearing from all of us consistently is retain stuff. That's going to be a best practice.
Right.
Agreed.
Another question that has come up related to defective pricing. Well, I think 2 different questions.
Last one, Greg.
What's that?
One more.
Okay. And that just relates to the sweep date. Does the sweep, the cert, have to be as of the handshake, or can it be another date? And I don't know what I mean, it's a little more context. I think there's negotiations ongoing, and it's hard to do the sweep of update all the ROMs, et cetera, rough order of magnitude estimates, update all of those as of the handshake. What are people's experience about getting that effective date of the sweep to be later, to be a different date?
Maybe we're gonna have to read David's new book to get the answer right.
Yeah.
Thank you.
Yes.
Well, and keep in mind the Shea Assad memo that's 5 days or death, whichever comes first. Well, this has been a fantastic panel. I don't think you left a single question unanswered.